Yeah, man, this is Graham Smoggle, and right now you're listening to The Edge in Kingston, Jamaica, right here, 105 FM. 105 FM.
Welcome to Legal Landscape, Season 6, Episode 8. Topic is restrictive covenants, the good, the bad, the in-between. On this episode of the Legal Landscape, we are going to discuss one of the most important legal topics which feature in real estate transactions, restrictive covenants. When purchasing or developing property, this aspect is often overlooked and the consequences may be dire. If restrictive covenants are ignored, it could result in denied financing or court orders directing property owners to demolish their homes. So today, we will explore how restrictive covenants are created, their usage, and their legal implications. If you are a property owner, real estate investor, a developer, or just interested in learning more about this important topic, listen keenly. We are joined by Allyson Mitchell, an associate in the Litigation Department at DunnCox Attorneys-at-Law, who will take us through the good, the bad, and the in-between. Welcome to The Edge, Allyson.
Hi, Dion. Good day. How are you doing?
I am good, and I'm on the edge of my seat with this topic.
I'm too. I'm ready to share.
On the edge of my seat with this topic. So, Allyson, I hope you're ready. You're well as well, too?
I'm doing well. Thank you.
All right. Well, so we're doing the championships here now. We've got all of this to go through in this time. And you're going to start off by telling us, what is a restrictive covenant, Allyson?
Sure. Well, simply put, it is a restriction on the use of property, typically found on the property title. Now, most restrictive covenants began as an agreement between developers when large parcels of land were being subdivided. So when a community has been carved up into house lots, restrictions may be placed on the title, and those restrictions remain on the land even if it is sold to new owners. This is why it's so important for purchasers or developers to learn about this topic, because they need to know what limitations are coming with the land that they wish to purchase or the land that they wish to build on.
Okay, so what is good, Allyson? What are some of the benefits to be had from a restrictive covenant?
Well, restrictive covenants usually serve to protect the neighborhood and to maintain the intended use of land in the neighborhood. So one example is that where you have parklands, you may have a restrictive covenant preventing the construction of buildings. Now, we can see how that will protect a neighborhood from becoming a concrete jungle by maintaining its greenery. In other contexts, though, these covenants may help to retain or increase property value. So properties subject to restrictive covenants may be more attractive to buyers who are seeking a certain level of exclusivity, privacy, or protection of their homes and investments. So although restrictive covenants are by nature limitations, there are many tangible benefits to be had from them.
Okay, so that's a good, tangible benefits. How about the bad? What are some of the downfalls of a restrictive covenant?
Well, sometimes restrictive covenants are implemented during a particular era, perhaps some decades ago. However, as time goes by and as society modernizes, those covenants may no longer be relevant. Then property owners will have to go through the legal process to change or to remove the covenants. That process can be time-consuming and it can also be costly. Another downfall, Dion, is that restrictive covenants that are overly restrictive can in fact reduce the value of a property.
All right, so Allyson, we've discussed the good and the bad. So now tell us about the in-between.
Certainly. So there are some restrictive covenants that tend to be neutral. For example, a covenant requiring the front of all properties to face the roadway. This type of limitation doesn't necessarily affect anyone. It's not particularly good or bad for anyone. But as we discuss the in-between, Zodian, it is important to note that some property owners may be in favor of keeping existing covenants if they believe it is still relevant and beneficial, while other owners may be interested in removing those same covenants if they believe that the covenants are obsolete or outdated or just no longer relevant. When that happens, one person may apply to discharge or modify the covenant, while another may object to that said application to discharge or modify the covenant. So in circumstances like this, the law attempts to find a middle ground between those two sides in a court action.
All right. So for the person listening who is really listening keenly now, how does one modify or discharge a restrictive covenant?
All right. Let me answer this with an example. So in 2017, a group of homeowners who live on Montrose Road in St. Andrew noticed that a developer was building an apartment complex in their neighborhood. The titles to these properties in that neighborhood contained a restrictive covenant that said only one residence could be built on a single plot of land. Now, to modify or discharge that covenant, the developer of the apartment complex had to file an application in the Supreme Court seeking to change or modify the covenant to allow an apartment complex to be built on a single lot. Now, this application had to be served in the parish council, NEPA, and of course on the neighbors who would lose the benefit of the covenant if it were changed. So, of course, the neighbors were not happy with the proposed modification, so they objected.
What are some reasons why persons would object to a modification or discharge?
Well, it really varies. It depends on the particular neighborhood and the particular covenant that the applicant is seeking to discharge or modify. But in the 2017 Montrose Road example that I used earlier, the neighbors were concerned that the apartment complex would interfere with their comfort and convenience, and that it would lead to increases in traffic and noise pollution because of the increased number of residents in the neighborhood. They also argued that the modification would depreciate the value of their land. So objections are usually mounted because neighbors take the view that the change to the covenant will deprive them of the tangible benefits that the covenant sought to protect.
Then what happens, Allyson, if someone does in fact breach a restrictive covenant?
Well, there can be few outcomes, but in that Montrose Road example, can you believe that the court agreed with the objectors and ordered that the developer should demolish the $100 million apartment complex? Yes, they were ordered to demolish it. It's my understanding that at the time the apartments and townhouses were already completed and that purchasers were actually living in the unit. So the court's order directing the demolition of the development was very serious and it could affect a lot of people. So the consequences of breaching a restrictive covenant are not to be taken lightly. The breach could also lead to an order that the offender halt the development, pay compensation to the neighbors, or take steps to ensure that the property is restored based on the terms of the covenant. This, in a nutshell, explains why this topic is so important for homeowners, developers, and interested listeners alike.
Very, very important. That's not money to sneeze at all.
Exactly.
Allyson, what's your hashtag Did You Know tidbit for us today?
Well, the Did You Know tidbit for you today, Dion, is if your property is in breach of a restrictive covenant, you may not be able to sell it, as the purchaser who may be seeking mortgage financing may not be successful, as the banks will refuse to mortgage a property that is in breach of a restrictive covenant. So to avoid these consequences, Dion, ensure to do your diligence, read your titles carefully, and of course, if you can't read them for yourself, be sure to retain an attorney at law.
Well, we've had Allyson Mitchell, Associate in the Litigation Department at DunnCox Attorneys-at-Law, the good, the bad, and the in-between of restrictive covenants. Allyson, if there's anyone who has any questions about this topic or any other legal queries, what do they do?
Sure, you can go ahead and you can call DunnCox at 922-1500, Or you can send me an email at allyson.mitchell, that's ALLYSON.mitchell@DunnCox.com.
Thank you so very much for all the information today, and that $100 million story. I think it's going to stay in the hearts and minds of a lot of people for a while. Catch you next week. Thanks, Allyson.
Thanks for having me, Dion.
Great having you too. All right, Legal Landscape, Season 8. What will they come with next week? $100 million, Patrice. Oh, man, I tell you. That's why you have to listen. You have to listen to the Legal Landscape. www.DunnCox.com. I want to thank the team for another fantastic episode in Legal Landscape.
You're listening to The Edge, 105.1 and 105.3 FM. Your life, your music.